You're watching TV News at 10 with Nifemi Oguntoye. We'll begin at the Federal High Court in Abuja, where Justice Emeka Nwite has ordered the interim forfeiture of 57 properties alleged to be proceeds of unlawful activities linked to a former Attorney General of the Federation, Abubakar Malami, and two of his sons to the federal government. Justice Emeka Nwite granted the order following an ex parte motion moved by Counsel to the Economic and Financial Crimes Commission, Ekele Ihanacho. The multi-billion naira landed properties valued at 213.2 billion naira are located in Abuja, Kebbi, Kano, and Kaduna states. The judge directed the publication of the interim order forfeiture in any national daily. The court also granted bail in the sum of 500 million naira to Mr. Malami alongside his wife and their son. Senior reporter Celestina Area has more.
Justice Emeka Nwite, while ruling on the bail application, ordered that each of the defendants must produce two sureties. The sureties are required to own landed property within Abuja's high-brew areas of Asokoro, Maitama, or Gwarimpa. The court also directed the defendants to deposit their international passports and other travel documents with the registrar of the court. They are barred from traveling outside the country without the express permission of the court. In addition, both the defendants and their sureties are to submit 2 recent passport photographs each. Pending the perfection of their bail conditions, the court ordered that the defendant be remanded at a correctional facility. The trial has been adjourned until February 17th.
We are comfortable with the bail conditions, and we are hopeful that within a reasonable time, we will fulfill those bail conditions, and the defendants will be released and prepare for their defense. Yes.
The Economic and Financial Crimes Commission, EFCC, had filed a 16-count charge of alleged money laundering against the former Attorney General, his wife, and their son. At the bail hearing, the EFCC opposed the application, arguing that Malami's international connections pose a flight risk, especially considering the gravity of the alleged offences. The anti-graft agency, through its counsel, further alleged that the former minister, being a highly influential figure, could interfere with witnesses, compromise the trial process, and ultimately evade justice. Justice Emeka Nwite has warned litigants and lawyers not to approach him in this case. He says anybody who attempts to test his will be dealt with. The best lawyers and litigants can do is to get good legal representation, either to present their case or defend same. Celestina Area, TVC News, Abuja.
Well, we're staying with that warning by Justice Emeka Nwite in the ongoing trial of the former Minister of Justice, Abubakar Malami, and 2 others. He did say none should approach him seeking any form of influence. Justice Nwite made the statement after delivering his ruling on the bail application filed by the defendants. They want both litigants and lawyers appearing before the court to understand the way the court works, saying indeed the best approach is to get best lawyers to plead their case. A law lecturer at the University of Hull, United Kingdom, Dr. Lateef Musbau, joins me on the news at 10 for more on this development. Dr. Musbau, Justice Nwite's warning appears to reflect deeper institutional concerns in the context of Nigeria's long history of corruption cases stalling or even collapsing. How significant would you say this is, a situation where a judge is distancing himself from any form of influence? And what does this say about the pressures facing the judiciary in corruption trials?
All right, Nifemi, thank you so much for this. And I think, like you have rightly said, this is a very significant moment for judicial ethics in Nigeria. On the one hand, it is positive and something commendable. I mean, seeing a judge coming out like this, I mean, to speak courageously. You don't often, see judges, do this. Some of them swallow some of these things privately, and why they still stick to their judicial ethics and all of that. On the other hand, it is also an unfortunate, and I would say, a pointer to the crisis that belie or underlie some of the things that people say about judicial system in Nigeria. It shows what the people in high places, they do, how they try to see judges behind the scene, to compromise and perverse the course of justice. So again, it is a very significant one, both negatively and positively. And on the positive side, I think it way more, because this is something that is already recurring. The judicial system in Nigeria, I mean, is riddled in so much corrupt practices. But unfortunately, most time the light is turned upon the judges and the courts, ignoring the people who actually ignite the corrupt practice from the outside. People from the bar, we've seen lawyers in the past who have been sanctioned, for similar infractions, and also litigants, the money bags who think they have the resources to go behind the scene to see judges. And this is why, as I said, it is positive and something we should commend my Lord, Justice Nwete for.
You wonder to what specific extent the legal profession itself become entangled in the broader corruption ecosystem. But specifically, what stronger safeguards or sanctions would you recommend to protect the integrity of corruption trials like this?
Well, at best, I think what the judge has done is the best that my Lord could do in that circumstance. In the first place, we do not really understand what exactly, the nature of people who try to see him and what they try to see him for. And in that light, I must clarify that seeing a judge behind the scene is not exactly something entirely strange, except that there are laid down procedure for that. If a judge will see a litigant or parties counsel, it is required by procedure that the other parties have to be there. In other words, a judge cannot see one party in the absence of the other. So in this case, since we didn't know exactly what was the nature of this approach, whether it was actually outright bribery or corruption or somebody, but it does suggest that somebody is trying to compromise my Lord. So basically, the legal practice in Nigeria is just, part of the system. So when people say corruption is endemic in Nigeria, they mean the system itself and everyone involved is corrupt, unfortunately so. So the legal system is also mere in this crisis of integrity. And I think the best we can do to safeguard this is when judges come out like this. And also when on occasion, they do not just come out to speak out. They also come out to wield, the sledgehammer by naming names, by calling out the people and reporting them to appropriate authority. For example, the rules of professional conduct actually bars a lawyer from engaging with judges in a manner to compromise them, whether directly or through their through their client. So sometimes a judge could go as far as doing that. If a lawyer is reported, for example, such a lawyer could be sanctioned, they could be derobed. Their license to practice in Nigeria could be withdrawn. And this is standard across all other jurisdictions. So basically, I think we should commend my Lord for doing what he did, and hopefully the relevant authority, the institutions, could probably even do more behind the scene, probably to speak to the judge and see to what extent, people have tried to see him and for what purpose. And if it warrants that some people be sanctioned, sanction could be applied against them.
Many Nigerians believe corruption cases rarely end in convictions, at least the kind of conviction that inspires deterrence. How damaging is this perception to the rule of law? And can assertive judicial conduct like this one, the warning we got from the justice, begin to reverse the belief that powerful defendants are untouchable?
Well, it's actually very damaging, I can tell you. And of course, we hear people say, for example, that you don't need to know the law once you know the judge. So the corruption perception is something that is so significant and that even makes even sometimes professionals to be wary of going to court. So these are issues that I think go beyond the surface that we see now, and that requires, as I said earlier, people in high authority to actually, and unfortunately, and that's the irony, it is big people or people in high places who could summon the audacity to want to see a judge or compromise a judge. The common man on the street does not do that or does not have the capacity to do that. So again, it behoves our political elite, those in high authority, the senior lawyers alike, to refrain from this kind of conduct, that could smear the image of the judiciary or even the legal practice itself. Because when things like this happen, it casts aspersion not only on the parties before the court or the court, it casts aspersion on the entire judicial system. We live in a global village. This is reported globally that a judge has issued a warning. And some people have actually wondered, and rightly so, that the judge should have gone far to even name names, although I do not subscribe to that. So basically, this is highly damaging. And I think it should serve as a clarion call to those who can, address these challenges so that we can restore our confidence and integrity in our judicial system.
Dr. Lateef Musbau is a law lecturer at the University of Hull, United Kingdom. Thank you for talking to us tonight.
My pleasure. Thank you too.